I'd like to welcome everyone to this panel on women in the judiciary. We have a very tight schedule, and I'm going to pretend to be a judge, even though I retired 3 years ago, and I'm going to gavel people quiet, which is really, I miss desperately. I'm going to speak just for a short time and sort of frame the issue. But before I do, I want to introduce our panel. It is an amazing panel. With Cynthia Aaron is the Associate Justice of the California Court of Appeals in San Diego. She was appointed to this position in January 2003. Prior to that, was a U.S. magistrate judge for the Southern District of California. She'll tell you a little bit more about her position as well when we start. Nan Duffley I've known for more years than I care to count. She started on the Massachusetts she's younger than I am considerably. She served on the Massachusetts Probate and Family Court from 1992 to 2000, then the Mass Appeals Court from 2000 to 2011, and became an Associate Justice of the Supreme Judicial Court on February 1st, 2011, one of the very best courts in the galaxy. Judge Saris I know for almost as long. We served together on the United States District Court for the District of Massachusetts. I believe that she has held every job in government there was to hold. She was a magistrate judge. She was a Superior Court judge. She became a United States District Court judge in 1993, right? She's now the chair of the Sentencing Commission, and she is also the chief judge of the United States District Court. How she does it all is a mystery to everyone in the world. Karen Moore is a judge of the United States Court of Appeals for the Sixth Circuit, appointed by President Clinton in 1995. There were really some rather wonderful appointments between 93 and 96. Huh? She was previously a professor of law at Case Western Reserve Law School from 77 to 95. She was a visiting professor here in 1990 to 1991, clerk for Harry Blackmun, District Court Judge Malcolm Wilkie as well. And then our final panelist is Wilhelmina Wright, who was appointed to the Minnesota Supreme Court by Governor Mark Drayton, where she has served since September 27, 2012.
Today.
Oh, today is her birthday as a judge. Before that, she was appointed to the Minnesota Court of Appeals, and before that as a trial judge on the Ramsey County District Court in St. Paul. She graduated with honors in literature from Yale University, which stands her in good stead in writing opinions, and received her JD from Harvard in 1989. I didn't go through everybody's date of their JD. I'm Nancy Gertner. I served on the United States District Court until 3 years ago when I came to teach at Harvard. My husband tells me that now that I can speak, I can't seem to shut up. I will try to do better, but as I said, I want to just frame the issue. Here's the way I'd like it to go. We'll spend a little time. I have a small PowerPoint just raising issues. One of the courses I'm teaching is on judging gender and diversity. So I just want to frame the issue. Then I'd like each of the judges to describe very briefly how they came to their current position, not to the staircase of their qualifications, but more in depth, if you can, about how it came to pass that you became a judge and in the position that you're in. And then I want to get to a real nitty-gritty question. And the nitty-gritty question is, does gender make a difference in your judging? That's what I want to talk about now. So the numbers. Right now, the pool of judges, 33% of Supreme Court justices are women, 32% federal appellate judges, 30% of the district court, 32% of state final appellate judges, and 27% of all judges are women. The pipeline of women from schools like this has of course been rather substantial for nearly 2 decades. 50% of law school students are women, 50% of entry-level associates at firms are women, 15% of equity partners in law firms are women. The bench is doing better, but we still need to ask why. What accounts for the percentages? Should we expect 50%? Are the numbers reflective of problems in the selection process? That's why I wanted to begin with how you got to be where you are. Does it matter if if judges are elected? Is there an issue with respect to the ABA review, for example? Reports suggest that minorities have a harder time getting through the ABA review. And I would imagine that when you begin to diversify the background of the bench, we've had some experience with this, so that it is not just prosecutors and big firm lawyers, the ABA review is less than satisfactory. Does the media have a role in this? There's a wonderful quote by a woman, Supreme Court Justice from Canada, Claire Heureux-Debay, who reported that when she was up for the bench in Canada, her neighbor was overheard saying to someone else, Justice Dubé just joined the court, a woman got on the court, she's a nobody. Is the confirmation process skewed in some way? Do we take any lessons from Harriet Meyer's failure to be confirmed, or in the light of the recent successes, does that make that issue a non-issue? What about the recall process? One of the first chief justices of a court to be recalled was Rose Bird. To be sure, she was joined by 2 others. There was much politics involved, but is that something we should look at? So that's the selection process issues. Does gender make a difference in judging? Dahlia Litwick, after Justice Kagan was nominated to the Supreme Court, said, beyond the fact that the court will be slightly more representative of the American people, what does the difference between having 1, 2, or 3 women at the court really signify? And that's an important question. Justice Sonia Sotomayor famously said, whether born from experience or inherent physiological or cultural differences, a possibility I abhor less or discount less than a colleague who was also speaking on the podium. Our gender and national origins may and will make a difference in our judging. I would hope, this was her famous remark, that a wise Latina woman with the richness of her experience would more often than not reach a better conclusion than a white male who hasn't lived that life. To be sure, in the opening statements of her confirmation process, she made it clear that her view is she simply follows the law, she makes no law, and concluded with that. Justice Ruth Bader Ginsburg, who came to the court with a rich background in sex discrimination law, wrote, I'm very doubtful about those kinds of results, namely results linking gender and judicial outcomes. I certainly know that there are women in federal courts with whom I disagree just as strongly as I disagree with any man. I guess I have some resistance to that kind of survey because it's what I was arguing against in the 70s, as in Mozart's opera Così fan tutti, that's the way women are. On the other hand, in a 2010 interview, she noted, women bring to the table their own experiences which inform their decision-making. Which is it, Justice Ginsburg? Or is it that we can't say the latter out loud? Justice Sandra Day O'Connor famously said, I think the important thing about my appointment is not that I will decide cases as a woman, but that I am a woman who will get to decide cases. And then quoting Justice Jean Coyne of the Supreme Court of Oklahoma, she noted, Minnesota. Did I say Oklahoma? I'm sorry, it's Minnesota. Sorry. That actually is, okay, that was a quote. Justice O'Connor noted, a wise old man and a wise old woman will reach the same conclusion in deciding cases in direct contradiction of what Justice Sotomayor said. And then finally, in a slightly different spin on this, Justice Shirley Abramson writes, what does my being a woman specially bring to the bench? It brings me and my special background. All my life experiences, including being a woman, affect me and influence me. But then she encouraged judges, women and men, to get involved in situations in which they would experience otherness, in which they would experience powerlessness. She described her experience visiting a courtroom after becoming a judge, dressed in a t-shirt, wraparound jean skirt, and sandals. The clerk was abrasive, the lawyers condescending, the legal activity taking place in chambers and outside the public view. She encouraged her audience, this was an audience of judges, to visit courtrooms and not just understand the perspective of another, but be, quote, an other, end quote. Experience what it is like to be the person in the courtroom without the name judge. So whatever she was saying about her own experiences, she was encouraging women and men to experience what being an other was like. On the other side of the coin, Sally Kenny recently wrote a book called Gender and Judging, and she argues that gender makes no difference in judging. But nevertheless, the bench should be diverse. And she writes, the more women judges look and behave like men, the more radical their presence on the bench can be because it normalizes women's authority and power. What does that mean exactly, looking and behaving like men? Does she mean exactly what she says? Or is she talking about diversity simply as something that simply legitimates women's participation in the citizenry? Or is she saying something else? What, after all, is gender in 2013? Do women have a, quote, different voice, as Carol Gilligan theorized? The notion that moral reasoning in which boys and men emphasize abstract rights, but girls and women stress context. There's a wonderful quote from someone who took Carol Gilligan's theory and said, women are interested in context, in facts, to which Justice O'Connor said, who isn't as a judge? Are women more empathic? Is judging about calling balls and strikes only, as Justice Roberts famously said? And in that connection, what does empathy mean? Who cares if the umpire is empathic? Or does this discussion of gender differences obscure the way that all judging is contextual? And in an article that Dean Minow sent me when I began to teach my class, she writes that there is no objective stance, but only a series of perspectives, no neutrality, no escape from choice in judging, no automatic outcomes. So is there no single gender voice? We are all so different at this point, differences in age, class, generation, experience. Is gender even a meaningful category now? Was it ever? Is it in fact the wrong question? Does every judge, male or female, struggle in the same way? Does asking the question, in fact, suggest that somehow women are different? No one asked the question during the years before there were women on the bench. Why are we asking it now? Does gender matter on particular courts? We have a wonderful representative group of state and federal judges. Does gender matter in appellate courts? Does it matter in trial settings? Appellate courts are more collegial. Does having a woman in the room make a difference? Gender matters, some studies have suggested, at the appellate level in discrimination cases. There's a 2005 Yale Law School study on employment discrimination suggesting that women on the panel make a difference in outcomes. Does it matter in certain areas, substantive areas? Is there less, more implicit bias with respect to women on the panel? Finally, should we acknowledge gender differences in our judging, or does that undermine the authority of the office? Does acknowledging the contextual nature of judicial decision-making enhance or undermine the public debate about judging? And then, this is just a silly cartoon, right? They tell me you gotta do PowerPoints with pictures and cartoons. I don't know from doing this. One of my clerks put this up. I wonder how my husband is managing at the construction site with my gavel. We thought it was cool. And I don't know whether you noticed Judge Judy was in one of the pictures, but that's another discussion. So let me first ask the first set of questions, which is, how did you get to the position that you're in? Just briefly, not just your credentials, I recounted those, but how did you choose to be a judge, what the selection process was like? Would you recommend that others in the audience do that? Let me start with you, Cynthia.
Okay, I started my career as a federal public defender, which I would not recommend as a pathway to the bench, at least not where I was living. Then I went into a firm with a partner, and we did almost all federal criminal defense. And I was getting kind of tired of that, wanted a change, and there was an opening for a magistrate judge in our federal court. The magistrate judges are selected by the district judges. And having been a federal defender, I had had hundreds of cases at least with all of the judges, and luckily they liked me, and they selected me. And I did that for about 8 or 9 years, and then there was an opening on the California Court of Appeal, and for a series of reasons, there were not a lot of other potential candidates, I think. And the governor had said he would not appoint any, he'd actually said he would not appoint any criminal defense attorneys to the trial court. But I guess I had been cleansed by my years as a magistrate judge and was appointed to the Court of Appeal.
And that's an appointed position?
It's appointed at first, and then after a 12-year term, there's a retention election.
And you haven't come close to retention election?
Well, actually, you have to run in the next gubernatorial election, so I was on the ballot in 2006 and not again until 2018.
Do you think elections make a difference in terms of women candidates? Is it more difficult or less difficult for women to make it in an electoral system?
I don't know that there's any intermediate appellate judge in California who has not been retained, male or female. So I can't really say.
Okay. Dan, how did you get to be where you are? And I want to know the secrets.
Well, I think I'm going to let me preface first a little bit about my background to explain how I'm going to answer. I'm an immigrant to this country, and I came here just before I was 7 years old. My mother's Chinese, my dad was Dutch, and I was born in Indonesia, and we came via the Netherlands when there was a regime change in Indonesia that required us to leave. I didn't speak English. I never knew a lawyer. I never knew a judge. And I wanted to be initially a teacher because those are the first professionals who inspired me. Even though my dad did always say I could be anything I wanted to in this country except president because I wasn't born here. And that, of course, says a lot about my family, my parents. I did go to law school. Ultimately, that's a whole other story. It came about as an epiphany when I worked at legal services for a semester during college. But anyway, I made it to Harvard and then into a law firm. And here's the important part. It did not ever occur to me that I could be a judge until somebody else suggested it to me. This actually was such an important recognition to me when I did become a judge that I've spent the rest of my life since then telling other people they ought to think about being judges, men, minorities, women, anybody who I think should think about becoming a judge. And that's most people who ever graduate from law school. I think they should consider it seriously. At that time, again, which when you look back on one's life, which is as long as ours is, you see certain patterns. And I see in this, what happened to me, a pattern. A sponsor, a mentor, a man. In my firm, I was the only litigation partner for a while, was a man who came back. He'd been on the Superior Court bench, and he really promoted this idea. He thought that I'd be a good judge, and he knew what it took to become one. And at that time, even though there was a selection process, there was a political, small p, component to it, as there is almost in everything you ever want to do in life, right? You have to know the rules, and then you have to know the real rules. So he helped me figure out the real rules, who to meet, and it was sort of like a campaign. Ultimately, I was appointed to, it's a governor's appointment after you go through a process in Massachusetts, and I was appointed to the probate and family court bench, which is where I thought it made the most sense for me. The process changed a little bit over time, and I want to speak to at that point I wasn't really thinking much about whether as a woman it made a difference, whether as an Asian American woman it made a difference to me, whether I was being appointed or not. Many things occurred to me after my tenure at Harvard. It did occur to me when I was here, by the way, I was in that 78 group, that there weren't enough women or minorities, and we did do something that we thought would make a difference in the numbers, and then we thought it would be inevitable. It took me another decade to realize there was no inevitability about the numbers, that even as you would come in, you had to continue to work hard to make it continue to be a difference, to have more women and minorities in places of power. So I did begin to recognize that it wouldn't be just me alone and my credentials that would result in advancement. And again, it was probably a number of forces. So here's another, maybe, something to take away. It took a lot of people who were willing to expend political capital, who thought it was important to have a woman or an Asian American, I don't know which was more important, maybe both. And it took decision makers, primarily the governor, to appoint to the Judicial Nominating Commission a very diverse group of people, so that the decision makers on the Judicial Nominating Commission, which by this point was pretty merit-based, you couldn't even call them. They wouldn't take phone calls. But there were lots of women, there were lots of minorities, there were gay people, there was a broad range of representation on this commission of about 22 people. And I think that was key as gatekeepers, that they were recognizing potential candidates for the judiciary among a broader array. There wasn't maybe less of the implicit bias that you might face. And beyond that, there was a governor, Deval Patrick, who was really committed to that diversity. So that's the end.
Well,
And he picked me.
What I'd like to do is just go through everyone, and then we'll have time for questions at the end. So can you save your question? Okay. Okay. And then you were appointed.
And then I was appointed.
Okay. Karen.
Well, I was a graduate of both Radcliffe College and Harvard Law School, and was very fortunate to get a clerkship out of the law school here for Judge Malcolm Wilkie on the DC Circuit, and I was his first female law clerk. And then I was very fortunate to get a clerkship with Justice Harry Blackmun, and I was his first female law clerk. And I think for both of those judges, the fact that they were Harvard meant that my having been Radcliffe Harvard meant that they thought, well, maybe she could do it. They were wonderful, and I view them as my definite mentors, and those experiences were fundamental to my development as a lawyer and my ultimate career. And also made me think, oh, being a judge is just the most wonderful thing in terms of the diverse array of questions that the two courts handled. The first, I will obviously date myself, the first case that was argued on the DC Circuit was the Watergate tapes case, and Charles Allen Wright and Archie Cox were arguing en banc to the DC Circuit. It was a very exciting kind of thing. So I ended up moving to Cleveland, working for a law firm in Cleveland for a couple of years, but realizing that I really wanted to be able to address questions that were of interest to me. And fortunately, an opening occurred in the faculty at Case Western Reserve Law School in Cleveland, and I was very happy to get that opportunity and ended up making academia my career, which I loved very much, and spent 18 years on the faculty with 1 year visiting as a visiting professor here, 90 to 91. That was a challenging year. I had 3 kids with me here. My husband commuted on weekends. My youngest was 11 months when we came, and I was in charge of all of the day-to-day issues with them. But it was a wonderful year. And then we went back to Cleveland, and at that point, I was still quite happy being a faculty member. I had explored the thought of being a dean. Actually, I was in the running for a deanship when I found out I was pregnant with my 3rd child. So I decided at that point that being a dean and having 3 kids was not going to work. So I withdrew from that. But in any event, when President Clinton became president, it turned out that there were a number of openings on the district court in the Northern District of Ohio, and I was interviewed by the staffs of the 2 senators, and they said, well, don't you think that as an academic you're not really very well suited for the district court? And I said, oh, I teach civil procedure. I really know procedure. And they said, well, what about the Court of Appeals? And I said, well, I would love that, but I didn't realize there were any openings. And they said, well, and it turned out Michigan and Ohio were fighting for this one seat. And so a year later, Ohio won the fight. And it turned out that there were 3 women who were finalists for this spot. And I felt extremely lucky that I was ultimately selected for that seat on the Sixth Circuit. So that was in 1995, and I have been enjoying my work on the Sixth Circuit since that time. The Sixth Circuit currently has 15 judges, and 7 are women. And it was interesting to me to be thinking about Nancy Gertner's questions, of which there are so many profound questions there, it's sort of hard to know, but the 7 of us are really quite different individuals. And so it's I don't know that there's any one answer to any one of your questions.
That's what I've learned. You see, that's the difference between being a law professor and a judge. You know, Hattie.
Well, I just wanted to start off with the absolute symbolism of this room for me here today, because it's not just that I'm here, and I'm thrilled to be here, but the first woman judge on our district court, Judge Rhea Zobel, is here. I'm here, and Denise Casper is here, and it makes 3 generations of women judges, all who are Harvard grads, on the Federal District Court of Massachusetts. And Nancy, of course, is a professor.
I like the dean graduated Yale.
I also want to mention that although I have 4 children, not a one of them wanted to go into law, but still, I view my law children as my law clerks, who all appeared, 3 women clerks who are here, 2 of them are grads. So I'm very thrilled to see the multi-generation. Oh, another one. So I started off wanting to be actually a journalist. I was on the Harvard Crimson, and I was going to be the great journalist, Watergate, Woodward and Bernstein, and as a young reporter, I was assigned Harvard Law School, and this was in 1972, and it really was the beat that changed my life, because I got to see the terrific women who at that point were fighting to expand the number of women in this law school. And at some point I started thinking, they were so terrific, could I be like them? And applied to law school. I didn't think it was auspicious that I was thrown out by Derek Bach. I thought it was a bad start when I was covering the movement. But I came here, and as soon as I came, I fell in love with trial work. For me, litigation was so exciting, and really almost from law school, I thought I would want to be a trial judge, and to really live my life in a way that might be my dream. And I guess I'm very lucky because that did happen. I clerked and then went down. I worked for a firm briefly, and then I went down and worked for Edward Kennedy. And saw the confirmation process close up. I was actually there when Judge Zobel came through, and another highlight was when Sandra Day O'Connor came through. Just watching how the process worked, it was a lot easier back then, I guarantee you, but just watching that made me understand the process. And then when I came up, worked for Bill Weld as Chief of Civil, and at that point, an opening came on the Magistrate Judge Division, and I can now say a baby. I was 35 years old. And I wasn't going to apply. Although I was chief of civil and sort of knew my way around, I figured it was like what Justice Abrams said. I didn't think I could do it. I was too young. I didn't have enough experience, blah, blah. So the Women's Bar Association actually played the utter critical role in my life at that point, headed up by Martha Coakley. They came to me. It was like an intervention. That's like my kids call it an intervention. They told me to apply. And in fact pressured me into applying, and I got it. And at some point, while I was a magistrate judge, a big cluster, Mike Dukakis had become the governor, and there was a cluster of openings. And I decided to apply for that and really be a full-blown trial judge, which at that point it was harder for magistrate judges to do, to actually preside over a lot of trials. So I did that, and I didn't get it, and I was sort of blown away. But again, the women judges, in particular, my very close friend, Judge Margot Botsford, said to me, stick with it, you'll get it. And I did come through on the second cluster and get it. And really, thrilling for me to be able to learn to be a bread-and-butter trial court judge in every county of the state. But then came the time there were 5 openings on the federal bench. And I went to my old boss, Bill Weld, whom I liked very much and was very supportive of me always, and I said I'd like one. And the word came back, forget it. Because at the time, President Bush was the president, and I had worked for Ted Kennedy. And while it never mattered to Bill Weld, it is a very political process to become federal district court judge. So I figured, all right, well, I'm pretty happy on the Superior Court. And then for some reason, those positions were never filled. Never totally understood why that was. But those 5 positions became Bill Clinton's. And at that point, and that's why I always say becoming a judge almost becomes serendipity. Judge Gertner was part of that crew coming through. I was part of that crew coming through. It was quite clear Senator Kennedy wanted a strong female presence to come through at that time. And really, if it weren't for him, I don't know that either of us would have been on the bench.
Surely not me. I think it's clear.
The whole process
Might have had a chance.
The
but-
whole process took 6 weeks for those days, and it really is very political. It's very, to use the word of the day, lean in. You got to go for it, but that's how I did it.
Wilhelmina? So sorry about the Minnesota mistake.
Not at all. I'm just a proud Minnesotan, but not by birth. I grew up in Norfolk, Virginia, and that is significant to me, being a judge, because Norfolk decided to close its schools during massive resistance after the Brown decision came down, rather than desegregating. So judges have always been my heroes once I understood the significance of being able to go to the schools that I finally got to go to, and the perils and struggles that my parents went through to make sure that even after massive resistance and after court-ordered desegregation, I still could get to those schools, because frankly, still there was some recalcitrance even after the second round of court orders. So I left Norfolk and went to Yale and then to Harvard Law School, and I arrived here wanting to be a lawyer, and yet knowing that the reason why I wanted to be a lawyer was because judges mattered in some way, but I didn't know a judge. I graduated from Harvard Law School having met only a few judges, and that was in the course of applying for clerkships. But please, if you're students, apply for clerkships. The most important informal aspect of my legal education came through my clerkship with the Honorable Damon J. Keith on the United States Court of Appeals for the Sixth Circuit. And he gave me a wonderful education that complemented the formal legal education that I received at Harvard Law School. And after leaving 2 years, after having spent 2 years in Detroit, Michigan, went to Washington, D.C., where I got to represent some of those school districts that had been really recalcitrant and help them implement their desegregation plans that they were still court-ordered to implement, and also some that wanted to voluntarily desegregate. So it was really from that experience that I thought, I have to take myself to Minnesota, and that is, to get there was love. And I think it's important for us to mention that there are other people in our lives besides our law clerks in our careers. So trying to figure out a dual career, high-achieving, highly ambitious couple's life could be really hard, and somehow my love for Minnesota grows from the fact that we landed happily in Minnesota, where both of us were able to pursue our careers. And it was very fortuitous for me to be then an assistant United States attorney, where I got to practice in federal court. I completely abandoned civil practice in that part of the Constitution that governs school desegregation, and moved over to the other part of the Constitution that really was governing criminal practice. And always found that no matter where I was in practice, I thought, boy, you know, I like representing clients, and I loved the advisory role that I played with school districts that were desegregating, because my experience was so much a part of, helping them understand the law and the significance of the law. But I wanted to be a neutral. I wanted to approach the law from a neutral perspective. And so having had that opportunity as a law clerk, it seemed to me that really I should try to become a judge. Now, I had arrived in Minnesota about 6 or 7 years before I decided that I wanted to be a judge in Minnesota. And I knew the federal bench well, and many of those judges had been former state trial judges, and so that helped with our process. But the single most important thing was our selection process, which is a merit selection process for vacancies that occur during the term of a judge. And so with that, I applied. The other thing that was very fortuitous, Governor Jesse Ventura was the governor, and he didn't know lawyers. And so he owed no lawyers judgeships, and he relied on this merit selection process, with vigilance. And
There were no female bodybuilders that he could have selected in exchange?
I think there's another court that had a female bodybuilder, but not ours. It was so it was a wonderful way for me to just toss my hat in the ring, and it's you don't get things the first time you toss your hat in the ring sometimes, and that was an important lesson for me, which is you pick yourself up, you dust yourself off, and you try again. I have, as a judge, now justice, been told no as many times as I have been told yes. And so one really important takeaway is that if you want it, you have to go for it, and you have to be willing to learn from your defeats, but not be defeated in pursuing your objectives. So I was on the trial court for 2 years in Ramsey County, and we have to stand for election within 2 years of our appointment. And I was very worried. My biggest fear, I was well regarded on the court, had a good relationship with the bar and the bench, and I was worried because I wasn't going to be 40 at the time of election. So, you worry about all the wrong things. Luckily, that was not an issue, and I did not have a challenger at that point. There was a vacancy at the Court of Appeals, and again, Governor Ventura, who was not required by statute at the Court of Appeals or the Supreme Court, was willing to use the merit selection process again. Why? Because he did not know lawyers and really relied on that process. And so I threw my hat in the ring again and was appointed to the Court of Appeals, where I spent most of my judicial career, and spent 10 years there. And then a new governor came in many years later, Governor Dayton, and a vacancy occurred at the Supreme Court, and so I decided once again to toss my hat in the ring. And it wasn't the first time I had applied to the Supreme Court under other governors. I had not been appointed, and so again, it's just really important to dust off that ego and not be willing to let other people's nose stop you from pursuing your goals. And the other thing that I just have to mention, I've talked about my marriage a little bit in terms of getting me where I am today, and a incredibly loyal Minnesotan, but by way of Virginia. But also I have a daughter, and we've talked some about our family lives, and she's in 9th grade. It's fun because now she is, in debate and really much more interested in what I do now than she was before, when the only thing that was interesting was the robe and her ability to play dress up and have great Halloween costumes with. But it's a fun and interesting time as I get to be a mom of a 9th grader and meet her friends who see the world as one with such incredible opportunity and so many role models for them as they envision their lives, and to be able to help them move forward with meeting challenges, meeting some disappointments, and really being able to be resilient and focused and ambitious, which is what we want for all of our daughters and sons.
Now, you sent me a case. This is a segue to the question that I think is the harder question to answer. You sent me a case called Nilsson versus Correctional Medical Services, which went to the 6th Circuit. Eighth Circuit, sorry. I'm really right on top of this. There's eighth. Went to the 8th. I get the holding right. It's just the courts. Went to the 8th Circuit on the question of whether a pregnant prisoner had to be shackled while she was giving birth, whether that represented a civil rights violation. And it went to the Court of Appeals initially, and then it went to the Court of Appeals en banc. And the Court of Appeals initially concluded that it was not a civil rights violation. And then in a decision by Judge Murphy, who was then the only woman on the Eighth Circuit,
Yes.
I'll get it right, she took the position that there were factual questions. Obviously, the issue was summary judgment, but there were factual questions as to whether that was a civil rights violation. And you sent it to me without comment. And so the question is, do you think that her gender made a difference in the outcome of the case?
Well, the en banc court flipped the three-judge panel. She authored the opinion. It is the only opinion that I know of in, I think it's F second, F third.
It's F third.
That,
Got that right.
cites to what you expect what to expect when you're pregnant, which this opinion describes in great detail the birthing process in which this woman inmate was shackled throughout her delivery. We know the number of centimeters dilation throughout the period of her labor, and at what point the shackles were taken off. I think in writing that opinion, we understand a lot about the experience of that woman as a result of having a woman write that decision. Now, Judge Murphy was the only woman on the Eighth Circuit, so it was not a decision that required a woman to determine that, in fact, there was a possibility of an Eighth Amendment and therefore 1983 cognizable claim in that case. She clearly had many male colleagues who agreed with her, although it was not a unanimous decision. But why I brought that to the attention of the panel was because it was a very intentional act not to leave out gender in this decision, and to really be able to explain the experience of that inmate from a uniquely female perspective, because she was going through something that was uniquely female, and why that mattered in the course of understanding the case. And so I think that it's really illustrative of the impact that women have on the court, because we bring our various experiences, and they are incredibly diverse as we are here and as this audience is filled with diverse experiences. But that's, in my view, the beauty of having, at least at the appellate level, a collegial court where you can learn from your colleagues' experiences. And I have learned as much from my colleagues' experiences, they happen to be male, who have been the solo practitioner in rural Minnesota practice, as I hope they have learned from me in terms of the various experiences that I've had, both as a lawyer and as a woman of color living in America.
Let me broaden the answer. So this was a case in which there was a woman's experience brought to bear on it. There's another case similar to that in the Seventh Circuit involving discrimination case. The plaintiff's name was DeClue, where she claimed sexual harassment, and part of the allegations of sexual harassment included, she was the only woman on the floor, included that the men were urinating on the floor in front of her. The Seventh Circuit declined relief because the absence of facilities for women, they concluded, was a disparate impact issue and not a disparate treatment issue, and she had not alleged disparate impact. There was a stinging dissent by Justice Rovner, who was a woman on the Seventh Circuit, essentially linking the history of discrimination in many areas to the failure to accommodate women's needs. And that was the same kind of decision as this. But more generally, in your work, does gender matter? Who wants to take it?
Yes.
You need to do more.
Okay.
Yes is not good enough.
Yes, and I haven't quite decided. I've thought about this for a long time, but I still can't tell you whether because I don't know enough about the science. There is some stuff that shows differences in males, females, and brain development, for example. For me, it is about the experience, but not just personal to me. I see my colleague, Barbara, who is on the bench with me, and my colleague, Cindy, who was on the bench with me on the appeals court. Illustrative, maybe, two cases, one very similar to this one, in which the decision had to do with a better understanding of the process of giving birth, and whether, while you're in the middle of a breech birth, you could actually think about calling up your doctor and asking for permission to not go to the hospital. So that didn't necessarily mean you had to have personal experience of that, but you need to be open to the possibility that there was something more going on there than maybe other people had taken note of. And when I was on the appeals court, there was a decision that seemed to come to, that was a very large court, and things that were in dispute went around to all the 25 people who were sitting, but not in the panel alone. So we had a diversity of views about rape and whether an aggravation occurred when you were beaten up afterwards and not during or before. And the women thought that rape wasn't about sexual intercourse. It was about violence, act of violence. And during that act of violence, sexual penetration in various degrees might occur. So it was a sensibility that did seem to come from women, and that were different from those that many of the men, this is not a universal, but it did seem to come that way. And for me, and there are many other examples, but it comes from having a different experience. And maybe a different experience for me, for example, having been here as an immigrant, I do think about those issues quite differently. It is, to me, and I saw this to varying degrees, it's not, just being deported. It's being banished to a place that you've never been, perhaps, where you don't know the language, when you've actually grown up in a different country and you think it's your own. It's being a woman who was an other growing up, sometimes a poor other, sometimes an Asian American other, sometimes a female other. And I think those open you up, being an other, to recognizing the otherness in the fact pattern that you might be thinking about.
I agree. I think it's very difficult to separate gender from your experience, if not impossible. And so to say that it's the gender that makes a difference as opposed to your life experience is probably an unanswerable question. I'm on a court of appeal, and I think I can say that I think that gender can make a difference in the process by which a decision is reached, and also perhaps in the way a decision is written. One of my female colleagues just noted last week, we're talking intently about an issue. There was some disagreement. We were trying to reach consensus, and the third was a man who came in and sort of left in disgust. And she just said, the men don't like to talk about the issues in depth, you know. Well, that's a gross generalization, obviously. But
sounds good to me, actually.
But there may be something to it. And also my experience has been that I'm the only one on my court who I've seen try to get sides together by saying, well, you think this, and then I wrote something, and how about this? You know, kind of the process of compromise. And again, another generalization, but I do think that's more of a female tendency to try to get a consensus that way, which is very different from being on a trial court and not having to do that. Consensus requires cooperation and
So
process.
appellate courts require some degree of collegiality. There are the cases that scream gender, which we've been talking about. But what about the trial court? Patty?
I don't want to be a contrarian here, but I think you have to think about it in terms of the different functions that judges have. I think in pure legal reasoning, how you analyze what a statute means, or how to construe precedent. I just think it would be, I don't know any basis for thinking that a woman conducts legal analysis any differently than a guy does. So I think that you have to, at least from my point of view, think of it in a different way. I think it makes a huge difference to have women in management positions in the court. I remember when I was on the Superior Court, a group of women guards came to me because they felt they were discriminated against. So it was important to have a female voice that they felt that they could talk to. I think sometimes in just even discussions early on, just discussions, and I'm sure Nancy may even remember this, with talking about what sexual harassment means or it doesn't mean. Some of those discussions are very helpful to bring your experiences into it. Or we even, I remember Maria, Nancy, and I worried about with jurors and whether you should get snow days off because, in fact, a lot of jurors couldn't, the kids were in school, so you get the day off. And I often wonder in managing a courtroom whether, at least in the beginning when I was less experienced, you felt like you had to be a little bit more strong and to make sure that everyone took you seriously. I don't feel that anymore, so I wonder how much that came with youth rather than and inexperience rather than gender. I think it's more a question of the legitimacy of the court to have a fair representation of women on it that represents the population, rather than that you come to a decision that would be different. I thought maybe I was just being too dense about this, but does it matter I'm Jewish? Does it matter I'm female? Does it matter that I came from a big trial court or have a little bit of a political background? Does that matter? Yes, sure, it all matters in some big, crucible of values, but I'm just not sure that gender drives how you reach a decision.
Do you want to, Karen, you want to comment on this?
Well, I alluded to this in my initial remarks, that on my court there are 7 out of the 15 women, and I think we are each very definitely individuals, and we shouldn't and couldn't be sort of joined together as having a philosophy that is gender-based, because we really are extraordinarily different. And I agree with a lot of what Patty just said in terms of statutory construction, is essentially something that is an intellectual matter that gender per se might not be a factor. But I do think that one's experiences in one's life definitely reflect what one thinks about things. And to give a sort of bad example the other way, I had a male district judge at the Inn of Court that I was in when I was a professor say, in all seriousness, that he had never seen an employment discrimination case where the employee had a valid claim. And I thought to myself, how can a district judge say that? There has to have been some employment case where the employee had a valid claim. And, it sort of was an amazing, this was, as I said, when I was a professor, I obviously got to know this fellow a little bit when I became a judge, but it was a very troubling kind of comment to me about someone's experience level and set of beliefs affecting how he viewed the world. And we do have a whole array of interesting kinds of problems in the federal courts, and the mention of immigration, for instance, and one of the areas of concern in some cases is female genital mutilation. And I think it is possible that is something that bothers certain people more than it might bother other people, but it's not necessarily male-female. I think people can be sensitive to problems no matter what gender they have. But the whole experience of life does affect one's views as to whether or not there is some underlying potential merit in a set of circumstances, or whether one has a closed mind to it. And my hope is that every judge has an open mind and will apply the law to the facts and be able to overcome any limitations of their own background that may make them have had less experience in a particular area, and be able to render justice.
Do you know this research? I'm thinking of research that I remember in which it was, it made a difference on collegial
Yes, on
appellate
courts.
decision-making, particularly in the discrimination area. And it also made a difference just that there were other people, minorities, say, on your bench with you. And I'm thinking of that because I think it makes a difference that there are men in family law cases who have a different perspective. And I think of what would so-and-so think? You know, and they think the same. And I think there is this, even without the direct exchange of opinions that say, here, I don't think that way or that way, apparently there is this just being there.
Well, there are wonderful comments that Justice O'Connor made about Thurgood Marshall at his obituary, that he made a difference in the room when they talked about things, because he could envision a world that was so different than the world that they did. Let me just sort of make, yeah. Oh, Patty has to leave.
I have one of the perks of being chief judge is I was asked to do the most wonderful thing in the world right now, which is to welcome Malala to Massachusetts. The young woman who, the girl, I'll say girl, who sort of stood up for women's education is getting a humanitarian award right next door in Sanders Theater. And so I'm sorry, and when it's over, I'll see if things are still going on, but gosh, how could I not meet her?
Could not,
So,
right.
Thank you.
Yeah.
I want to try to give a concrete example of what, I agree that I don't think the result is going to be necessarily different based on gender, but the way an opinion is written can be different. And the example that comes to my mind is there was a case where a judge had ordered immediate visitation when a father got out of prison, which was 3 years in the future. And I had written an opinion that gave a lot of the history of the spousal rape. The father was in prison for the spousal rape. The things the judge had said that showed a lot of bias against the woman. And the judge went against all of his experts' advice in ordering immediate reunification of the children with the father. And I had male colleagues who were, one was very uncomfortable with the way it was written and really said, you just want to embarrass the trial judge, don't you? And I thought the context was so important that I really had to insist that it either be in the opinion or that I would write a separate opinion including it because it was integral. And so it may not have changed the result. They were willing to vote for the result. This colleague did not want all of that in the opinion. So that's what I was thinking of.
Let me just sort of make one remark and then open it up to questions. It's one thing, as just Judge Sarah said, that statutory interpretation, we were all alike. The only thing is that when you go through the cases, some of the cases that I've described, in discrimination cases, sexual harassment cases, a federal judge is called upon to determine if the harassment was severe and pervasive, a qualitative judgment. We are to look at complaints to see if they're plausible. What was plausible to me may well be implausible to someone else. So much of our constitutional law is a function of, uses the determination of reasonableness. And there's been a debate for the longest time about what's the norm of reasonableness, reasonable man, reasonable woman. The Eighth Amendment case that we cited was a question of whether or not shackling a pregnant woman was cruel and unusual punishment. There's no guidebook, there's no formal account that can get you to that. There's no originalism that can get you to that. Trial judges have to make credibility determinations all the time. Credibility determinations that come from your life experience. The people you regard as credible may well be different than the next judge would regard as credible. So to characterize we all are alike, we're all alike, and the frameworks oftentimes invite our differences. Whether gender summarizes that is another question. Someone back there had a question. I didn't want to put you off. You, yes.
For when you applied, some people know this, but when you applied to be a judge and went through the selection process, if you had children, did it come up in the selection process? I'm a judge, and it definitely came up in my process, and it came up for other people before, and so I was interested if it came up or.
Came up how?
Came up like where there were specific questions directed to you being a parent.
And implying that you wouldn't be able to do both?
Questioning, like how your parents being a parent, what were your child care arrangements, the assessment of if you pay taxes on health you had. These are all things that have happened. Whether how you're going to fund the education of your child at a judge's salary. These are all.
Where's she from?
Where are you from? Don't tell me if you're from Minnesota, I take back everything I said. Well, there's a like issue. Juliet Kayyem, who's married to Professor David Barron of this faculty, announced that she was running for governor. And on a program that I was listening to, someone said, "How can she run for governor? She has 3 small children." Period.
Well, one of the reasons why I brought up my daughter is I want people to know that having children is a wonderful blessing if you would like to have children, and it doesn't impede my ability to do a great job. In fact, I've had experiences that only a child would have led me into those circumstances, and as a result...
Gives you humility.
Oh, boy. Try to reason with a 4-year-old when you think you know what's right. So I don't deny that there can be real bias against that, and my perspective is one in which I think we have to speak about who we are, because each of us comes into any gathering, any room, any decision-making process, any classroom with a set of values and credentials. And to the extent that we can present them in a way that is positive and in a way that helps people understand our differences, perhaps, and why they matter or why we're so similar despite them or because of them, is important. But I learned early on, there was no way I was going to convince anybody that I wasn't black and female. And so I had best embrace that and maybe revise for someone else what that meant in their mind about qualifications, experience, whether I am amenable to a particular argument, or whether I should be deemed responsible enough to have the kind of authority that a judge does have in the lives of others.
Let me ask a question sort of related to that. Justice Ginsburg describes that when she was on the D.C. Circuit, at the very beginning, she made sure that she took the most complex regulatory cases to prove her mettle and to prove that she could be smart in areas other than discrimination law. Did you all have the experience of feeling like you had to prove yourself, even though you were on the bench, prove yourself either by voting by a decision that was not in favor of a woman, prove yourself by doing cases outside of your comfort zone? Did you feel that kind of pressure? Karen?
No.
Okay.
And I think on my court, everybody does all sorts of different kinds of cases, and the fact that there had been, the Sixth Circuit actually had the first woman federal court of appeals judge appointed by President Roosevelt, Florence Allen, and she was appointed in the 30s. So she was a pathbreaker, but then Cornelia Kennedy was appointed by Carter, and Alice Batchelder by Reagan and Bush to the federal courts, and Sissy Daughtry by Clinton, and then me. So we had a whole series of women who had led the way, and everyone knew that women could do the work. But I could see that could be a problem in a court where a woman is the first woman and where there are skeptical people, but not in my court.
Anybody?
There, I think, were skeptical people on my court, not the current court. And I didn't do anything different, but I think I recognized that for some, it took longer to win respect. That was true. And I'm still interested in what you said. I had my first child here in my last year, and I did get those questions from some law firms who were people who were interviewing me. I haven't had it since, and it just never even occurred to me that people would, because people just don't, they think that maybe, but they don't ask that anymore. And it's possible that they figured if I had 3 kids and was a litigation partner, then maybe this would look like an easy job. I don't know.
There were times when I could cancel court because one of my kids was acting up that I actually was prepared to believe that the U.S. District Court was the mommy track. Only kidding. Any other questions? Yes.
Can you describe
describe what you see differences in terms of those who advocate or litigate before you between genders? How are the women attorneys presenting, if you can generalize, and how do the male attorneys present, if you can generalize?
Since I'm the only trial judge left on the panel, right. I mean, I think it's very interesting. There's no question that young women continue to have, in my view, a harder time starting than young men. In other words, it's almost like the presumption of competence will attach to them more quickly than it certainly did to me when I was a trial lawyer, but it's been more of a struggle, more of a disconnect. And in Boston in particular, we had, I think, among the worst records for female litigators in federal court. Aside from on the criminal side, there were many federal women litigators. On the civil side, there was next to none, and they were typically second seating the male judge. In terms of the way they presented, I didn't really see a difference. The women who could get through that kind of gauntlet were fabulous, but I wanted to see them get through the gauntlet. Anyone else?
One thing that's amazing to me in the Court of Appeals, at least in my Court of Appeals, is how few women lawyers there are doing oral argument. We might have 5 cases argued, so we'll have at least 10 lawyers. Many days there are 1 or 2 women who are arguing. And the thing that I just find so amazing is that with women being 50% of law school classes these days, where are the women? Is it that women are not picking litigation? Is it that women are leaving law? There are many possibilities, and I'm sure people have statistics that we'll see in the course of this weekend. But I am really taken aback that we have the women judges, but we don't have the women lawyers arguing.
Well, getting to argue in a federal circuit is a plum. And so, at least I know when I was a junior associate, even though I briefed everything, I didn't get to go stand up in district court or in the Ninth Circuit. It's only when I went to a U.S. Attorney's office that I had control of my own cases that I always had to go to the Ninth Circuit.
And some of the women that we see arguing are the ones who are doing the pro bono cases in the big firms. We have a number of big firms, not just in the Sixth Circuit, but from DC and other places, that are sending their young associates to argue pro bono cases that they've taken up.
Yes, back there.
At the Supreme Court of Canada, we had 4 women judges out of 9, and now we have only 3. And when the 4th woman stepped down, she specifically mentioned the media, that it was very important that there would be more women named on the Supreme Court of Canada. And it seems as if one of her concerns were that it changed the atmosphere of the court and the type of arguments that would be argued. Not that the reasoning would be changing, but that the whole atmosphere of the court changed. And a fluke made it so that 3 of the women were in the same wing, so they called it the chick wing. They called it themselves that way. No, they called it themselves that way. But they felt they could go to each other's office. They felt they were able to, even if they didn't agree with each other, they felt there was an atmosphere, a feeling of being able to discuss certain issues, and they felt it made a difference in the way that they were able to convince their colleagues. I don't know what you think about that.
There are questions about the Carol Gilligan, a different voice concept, is really on a continuum. So on the one hand, it is partly the notion that in fact women think differently, which is largely rejected. On the other hand, it's also the notion that women will, on that continuum is that women will reach out, will try to be engage in collective decision making more than their peers, and that's the kind of process that you're describing. Is that your experience, that the women are reach out and women would consult much more than the men consult?
That is not my experience. I am on a court now. There are 7 of us. Our Chief Justice is a woman. And the experience that I've had is that that's no different than the experience I had at the Court of Appeals, where we were still a minority of women and occasionally would have an all-woman panel, but not very often. So I think it so depends on the nature and the personality of the individuals who come to the court and how they interact with each other and whether they're outgoing and extroverts or whether they're introverts. So I think there are many other things that have an impact upon the interaction of judges and justices on an appellate court where we are involved in collegial decision making.
There's a wonderful remark that Justice Ginsburg famously made again about how, I don't know whether it was when she was the only woman on the Supreme Court, but she said that, and I'm sure that every woman in the room has had this experience, that it's very structured speaking in the conferences. And she could say something, but that essentially the point that she made would then not be taken up until a man repeated it. And everyone is shaking their head with respect to that.
I've certainly had that experience.
Right.
There's also, we have that same formality, which is very unlike the appeals court, where we always were in each other's offices, and that was across the board. It wasn't just, it was just the informality of the court. But I do think that in the 3 years that I've been there, that we go around by seniority, and it's pretty strict, and we don't really even go around again. You could say we started interrupting, and it's mostly women, or you could say that we've started inviting more discussion, but I see that as largely being initiated by the 3 women to some extent, and I think it's a welcome change.
You know, I had a completely different experience. So shortly before I went to the Supreme Court, I was on a panel, and there were 3 women on the panel, and in my experience, we were less formal than we are now at the Supreme Court, and speaking in order and not interrupting and only asking questions that really are clarifying questions during the course of the conference, at least initially. And I found that my experience, it was almost prescient, right before I came to the Supreme Court, was so important for me to understand the benefits of having those kinds of formal rules about how you engage on issues that you care about deeply, you have strong views about, and want to make sure that everyone is heard. So I am someone who believes that having formal processes for conference, and I'm one of the junior justices. I just moved up fairly recently from being the most, so I was speaking last. But still, I think that it brings about a much more refined and disciplined discourse across difference in particular, but even to make sure that everyone is heard.
Any other questions? Yes.
I noticed that when Judge Saris left, she took with her some of her law clerks who were women. Maybe those were just the ones who were here today. I'm curious about your own practices in selecting law clerks and whether you try to give a nod or look to give opportunities to women, or whether you think, no, you shouldn't do that.
All of my clerks, when I was a magistrate judge, were women. It wasn't that I said I will hire only women, but it just worked out that way. And then when I started on the Court of Appeal, I had 2 men. They were my first 2 male clerks, and now I have 1 of each. It isn't, to me, a gender thing. It's a sensibility issue, and sort of seeing the world in a similar way. It makes it for a much less toxic chambers, I think. Happy chambers.
I have 4 law clerks at a time, and I hire the best people who apply, and I have never had fewer than 2 women law clerks. I've sometimes had 3 women. But it's interesting to me how some of my male colleagues often only have male law clerks. And I sort of wonder, is it that they don't see who is the best? Or is it that they are getting predominantly male applicants and not many females, or once this sort of cycle starts, do more women apply to women judges and fewer women to these particular male judges? And there can be many explanations, but I hire people who I think are the most outstanding people, that are people that I would be happy to work with. So I want my chambers to be a happy chambers. I don't want there to be infighting and grandstanding and bad behaviors of any kind. So anybody who sort of has a suggestion of bad behavior in an interview or otherwise is out, whether they're male or female.
And whether they're fabulous or not, right.
Right,
Just
exactly.
add one thing. I agree with all those comments. One quick thing is, there's a cutoff, but I actually have lowered it because my concern is that the component of a grade component is class participation, and I'm wondering, I'm suspicious that sometimes men are given more credit on that part, so I didn't want to preclude a good woman in the pool.
Let me say, they're about to kick us out. I think that this is an interesting discussion about whether gender and other experience makes a difference. I also think that the question of why we are not at 50% is an important one, and so long as the sources of women judges are big firms, prosecutors' offices, et cetera, those numbers are going to ultimately, I believe, have an impact of who's on the bench, so that the discussions in this panel have an impact on the discussions elsewhere. Thank you all.
Absolutely.